SJC-13461, Commonwealth v. Eden C. Jacques.
Attorney Daniels.
Good morning, and may it please the court. My name is Attorney Josh Daniels, and I represent Mr. Jacques in this appeal. My client was denied his constitutional right to present his entire defense through cross-examination, and for that reason, we're asking you to reverse for basically three independent reasons. The first is that the Berry allegations are not sexual conduct within the meaning of the Rape Shield statute, and so the statute shouldn't have come into play at all. The second is that even if that's incorrect, the judge still abused his discretion by keeping them out. And the final one is the Commonwealth's closing argument. I'd actually like to start with my second point because I feel like that has the most ground that needs to be covered. So even if the Berry allegations are within the scope of the statute at the threshold, I would say that the implicit constitutional exception to the statute that this court recognized in Joyce would still come into play.
We've been very narrow in this area with respect to Bohannon, Ruffin, and Polk, correct?
Pardon?
We've been very narrow as far as carving exceptions, constitutional-based exceptions to Rape Shield. One is Bohannon, the second is Ruffin, and the third is Polk, correct?
I don't know exactly what you mean by narrow, Justice Gaziano. I think
more than broad.
I mean, I guess it depends.
In fact, doesn't Bohannon say it's a narrow exception?
I mean, Bohannon says at the end of the opinion, this is not a Rape Shield case. This is a case about essentially what we now call Mass Guide to Evidence 608. And the reason that they said this is not a Rape Shield case is because this is only about allegations,
But there's a constitutional overlay to everything.
Yep.
Right, and that's what we're talking about, your ability, the Sixth Amendment ability to present a defense.
Yep.
But be that as it may, we've had false accusations, sexual experience in Bohannon, and then this confabulation, disassociative confabulation in Polk, correct?
As far as your cases are concerned, there's also Baxter from the Appeals Court, which I view as sort of in the same vein as Polk.
Right, but I'm just focused on the SJC cases.
Yep.
So why is it that we should expand this to a fourth category of consistent allegations?
So I don't see it, honestly, as an expansion. I think if you, like, as you said, there's a constitutional overlay to all of this. I think all of these cases ultimately are applying general constitutional principles in interpreting the sweep of the statute. And if you take a step back and you look at particularly Baxter, Polk, and Ruffin, I think the common thread that runs through all of them is that at their core, they all deal with narrative recycling. In two of those cases, the narrative recycling is probably unintentional or unwitting. That's the confabulation theory. And in Ruffin, looking at the appeals court's decision at least, it seems to be intentional narrative recycling. The only difference with Ruffin is that in that case, part of the relevance came from the extraordinary sexual knowledge issue. At the same time, this court—
That's your term, this narrative, right? You're making this up. The cases don't say that.
I mean, I think that is my gloss on the cases.
Okay, so let me ask you something on that point, which to drill down. Justice Englander said that the striking similarities was hyperbolic. When I look at or try to match what the victim said in the earlier incidences with this case, I see a lot of them have to do with the child's unfortunate circumstances in that she has trust in adults, she has to share a living room mattress with a relative. That's just her unfortunate life circumstance, right?
So I think first of all, the question is whether a reasonable jury looking at these two narratives side by side could draw a rational inference of recycling. And I get that from Joyce. And an epiphany I had yesterday is this is essentially a conditional relevance issue. So I think if the narrative is in fact recycled, then
Conditional relevance isn't good for you because we go to the judge's discretion on that, right?
right, but the lens through which you view through which the judge is supposed to exercise that discretion is essentially in the light most favorable to the proponent.
So tell me why Justice Englander was wrong.
So I think he's wrong because he's viewing the evidence and or for the court is making the judgment of whether they are convinced by this inference of recycling, and the question needs to be whether a reasonable jury could have this available as a rational inference. And I think it is a rational inference, particularly if you look at the number of details and how specific they are side by side in both of the narratives. It may not be the only inference available, but certainly a jury would not be irrational or taking leave of its senses.
Striking similarities, could you go over those?
Right, of those facts,
Yeah.
So you have, I think the best example for me is just looking at the narrative details in the two living room episodes involving my client and Mr. Barry. So it's not just the abusive behavior that is the same, it's also the setting.
That's where she lives.
I mean, she wasn't living at Normandy Street, she was visiting at Normandy Street.
But that's where she sleeps, in the living room.
Right, but I mean, and it's also the fact that like both sisters are involved.
I interrupted you. Continue for Justice Kafka, the litany of similarities.
Yeah, so you have the same two sisters in the same setting, sleeping in the living room in these two different apartments. There's the same alleged abusive behavior, getting into bed and rubbing their legs, and basically the same words uttered in response.
Okay, let's before you get to the words, those are just so common, the first part of this. I mean, you know, you and I, we've read hundreds and hundreds of these cases. Those two don't get us into anything distinctive, do they?
I think
Rubbing of the legs and sleeping in the living room, that's just.
I think when you put them all together, it becomes
I'm cutting you off there because I don't find those distinctive. Tell me point to something distinctive, because that would be very helpful. Something that I don't see in 100 of these cases.
So in both episodes, the response that this provokes is basically the same words uttered in response. In one story, I think Denise, the pseudonym, is the person who she attributes it to herself. In the other story, she attributes it to her sister, who I'm calling Jane. And it's something to the effect of, we're going to have a problem if you don't stop. And I think the whole is basically more than the sum of its parts. And when you put all of this together.
Say, we're going to have a problem if you don't stop.
Yeah.
Meaning that children are going to be punished if.
No, the assailant is going to have a problem if he does not stop rubbing their legs or whatever he's alleged to be doing.
Again, isn't that standard?
And that may be
Hundreds of cases.
And that may be an argument that the Commonwealth gets to make to the jury for why they should not find that this is recycled, but I don't think that's a reason to keep it away from the jury. I see that as basically just a factual dispute, which if you look at Joyce, if you look at footnote 10 of Baxter, the fact that this conclusion would be contested, that a different interpretation of the evidence might be available, is not a reason to keep the evidence away from the jury.
On the facts, as I tried to line them up, reading the briefs, as I see a lot of them, they have to do with unfortunate circumstances, including the person's walking around with the penis exposed. That's what's going to happen in a rape, and where the sisters live, where they sleep, etc. But the ones I found similar are the victim was told by an adult that the defendant and Barry were both sneaky, and that Barry and defendant offered her $20 to dance or have sex. Are those two facts? Am I getting that wrong? Are those two facts the similarities?
Yes, they're part of what I say are the details that are recycled between the two narratives. Okay. And again, this is, you look at it in the light most favorable to the proponent. The question is, could a rational jury find that these narratives are recycled?
How's it a light most favorable? Because it's an exception to the Rape Shield Act. I don't agree with your first argument, by the way, as you could probably tell. But this has to be an exception to the Rape Shield Act, right?
Right, but I mean, if you look at the analysis in Joyce, you're assuming that the jury would believe this evidence, and basically you're looking at whether a rational conclusion that could follow from that would bear on whether it has any rational tendency to bear on the accuser's credibility. And it doesn't matter if there might be a different view of the evidence. That is something for the jury ultimately to resolve. It's not a reason to keep it away from the jury. And I think...
So just articulate the theory for me. So your theory is that previously this same victim was victimized by Mr. Berry, and therefore she's, what, making this up the second time around?
She drew on her earlier experience with Mr. Berry to fabricate her initial allegations against my client.
On the undisputed experience with Mr. Berry, the actual victimization of herself by Mr. Berry in order to fabricate something against your client.
Yes.
Okay.
And I think that's very similar to Ruffin, where the theory again...
Ruffin, didn't that involve a young victim?
It did.
And so
that's the only difference.
Well, and it was crucial to show why that young victim would know of, this kind of sexual misconduct.
Right. My point about Ruffin is, at their core, the theory is the same, which is the victim drew on her earlier experience of victimization to fabricate a new allegation. That is the same in both cases.
Your purpose is to show that the victim here is lying, whereas for Ruffin, the purpose was to show why the victim would have had experience in these sexual matters, because she was so young otherwise.
I mean, I think... Yes, the only sort of clarification is that I think in Ruffin, as I read the appeals court's decision in that case, that this court then flipped, the theory in that case was also that the victim was lying. But it was part of the other reason why this was so important to the defense in Ruffin was to explain how she could have the wherewithal to fabricate these details given her young age. But this court, again, explicitly did not limit its reasoning to that particular fact pattern. It said there might be cases in which it could be relevant for other purposes. The defendant will need to show what that relevance is. I think here, if the jury accepts that this is recycled narratives, then I think that self-evidently bears on the credibility of the accusation. And the only other...
In the trial judge, in making the assessment of whether or not to allow the cross-examination that you wanted to do to continue, does the trial judge have to balance the policies of the Rape Shield against your client's constitutional rights to present a defense, or is it automatic that your client then gets to present the defense?
So he has to do that. He has to balance the policies of the Rape Shield statute.
So tell me why the trial judge abused his discretion in the balance that he performed.
Sure. So I think the biggest problem with, there are two problems that I see with the judge's decision. One is it's not clear to me that his reasoning actually engages in that balancing. His primary reason for keeping this out is, I haven't seen a case exactly like this before, so I'm not going to do it. And
he's right, because
every case that recognizes this exception is also the first time in which that exception is recognized. And
right, but in the context of, and I know you don't agree with this, but in the context of these exceptions being narrowly drawn, and each of the cases suggesting that they're narrow exceptions, how can we say that the trial judge abused his discretion on that particular reasoning? I
mean, first of all, looking aside from Bohannon, which is not a Rape Shield case, I don't know that any of the cases expressly say, this applies only in this sort of situation, or characterizes it as narrow fact-bound, as
what
an
was the
exception that's
second-
fact-bound in the same way.
What was the second reason that you suggest that the judge abused his discretion?
So if I could gild the lily on my first reason, I actually see a lot of parallel between what the judge here said here and the reasoning of the judge in Baxter, which the appeals court overruled.
Right.
So there is that parallel there. And so to the extent that Baxter is good law, and no one has questioned Baxter's goodness as law, I think that's a way there. The other point I would make is even like looking at the policies of the rape shield statute and looking at, every conceivable reason you have for keeping this out, I think the only one that actually even arguably points toward exclusion is the concern, which is an important one, about potential trauma or re-traumatization of the victim. As I say in my reply brief, that can't be the entire analysis because otherwise the Constitution is going to lose every time. And like that concern is present in every single case. So if that alone is enough to keep it out, then a bunch of your cases are wrong. The other reasons, the conceivable reasons to keep it out might be, this is for an improper purpose. Everyone, I think, agrees, including the judge, that this was not for any purpose. It was not being offered for any purpose prohibited by the statute. There are at least 8 cases between this court and the appeals court that where that purpose is absent have been reversed on these grounds. And the cases going the other way, I think, are all distinguishable for various reasons. And then the only other thing, putting to one side, I think, the Commonwealth's post hoc rationalization about the effect on the trial, which the judge said nothing about. And if it were at all of concern to him, he would have said something about it. The only other reason...
Effect on the trial as far as confusion?
Yes.
Okay.
The only other reason that the judge did point toward is this idea that adequate cross-examination had already been allowed, which I think the judge misread the way that the cases actually look at that, which is if you look at Stockhammer, what this court said there is you need to consider every separate and discrete basis for impeachment. And how did I put it in my notes? The question is whether the evidence was needed to explore or air the defendant's chosen theory of defense, not a more watered down or generic one. And so the question is whether these allegations were essential to the theory that the defendant wanted to pursue. You cannot air a recycling theory unless you can compare the allegations and let the jury see how they might or might not be recycled. And so I think there's very little reason actually pointing to exclusion. And, I think the court may disagree, but there's at least a rational inference that justifies sending this to the jury. And for those reasons, I think the judge's rape shield ruling is wrong and can't be supported. I'm happy to take questions about my other points, but I'm not overstaying my welcome.
Okay, thank you.
Thank you.
Okay, Attorney Doherty.
Chief Justice Budd, and may it please the court, Andrew Doherty for the Commonwealth. With me is Assistant District Attorney Kyle Sikanolfi, who was the trial attorney in this case. I'd also like to acknowledge Jacqueline Lamont, who is our Chief of Forensic Examiners, who's watching as well, who conducted the forensic examinations of the victims in this case. This court has always tread very carefully when it comes to the rape shield. And not only with the rape shield, but in all cases involving rape victims, this court has always acknowledged that there is a third factor in play, which is in jury's deliberation, which is society's innate and ongoing misogynistic skepticism about a rape victim's testimony. That is expressed in the rape shield as it carefully it discusses things like Ruffin, where it isn't simply that it's relevant, it's that it's dealing with the assumption that society has with respect to chastity norms, the fact that a child wouldn't know of these terms unless she'd previously been raped.
Given that, as we look at the continuum of these cases in Bohannon, Ruffin, and Polk, now we have presented to us a fourth category that of recycled allegations. As I look through, read the appeals court decision and look through the allegations, I get the similarities, which are, as I've said in the prior question, and that are a product of the unfortunate circumstances this victim found herself in. But it seems striking to me that in the prior allegations against Barry, the victim told, an adult told the victim, be careful, this person's sneaky, using that one particular word. And then that, and more striking, that Barry and the defendant both offered her $20, the exact same amount, to both dance or have sex.
Sure. So
To me, to be striking.
So,
Please tell me why they're not,
so-
and why they're not admissible.
I understand the question. The first thing I would say is you have a teenager using colloquialisms to describe how she received warning from some concerned adult in the house, and she used the word sneaky. If we start going down a road where we're concerned about the language that a rape victim is using, we're opening the door to the kinds of concerns that this court has expressed. Most recently, I'd say, in the dissent in Alvarez, but also in maintaining the first complaint doctrine in King, that when we start guessing how weird it is, the language that a victim is using, which is really what the defense argument is. Isn't it weird that she was raped twice?
Well,
Isn't
it's
it weird?
unique. It's unique to say that the same, or similar, another aunt told me it was sneaky, he was sneaky.
Right.
And not, and that, maybe like creepy. I think people use that a lot now. Sure. But the $20 does seem a little unique.
I beg to differ.
Okay.
Dollars to dance or
It
have
is
sex.
it is offering rewards or inducements in order to do something that pushes that
specifically
boundary.
the same amount for the same reward, for the same acts.
If it was $15.30, if it was some distinct number that stood out on its own, I mean, I don't know that saying I'll give you $20 for a dance versus I'll give you $10 for a dance makes all that much of a difference. What matters here is you have a child saying, he offered me money to dance.
But isn't that something that you would argue then on redirect? As opposed to not allowing the defendant to have this defense, which is
So we say,
constitutional.
isn't it weird that, so I would say this, isn't it weird that we're talking about Eden Jacques' rape case, but let's also talk about the fact that something that wasn't brought up in direct, but rather in cross-examination, didn't you offer $20 for this dance? We're now dealing with minutia, right? Isn't it strange that?
But isn't that what we do when we look at bad act evidence in general? Like, so suppose there's a robbery of a convenience store, and you, as a prosecutor, want to get in bad act evidence. You would say there's some signature conduct, that the person that robbed the convenience store on one day and then robbed it 5 days later was wearing a clown mask or
Right.
something that was unique.
Right.
The minutia, the uniqueness is what makes it admissible in many cases.
So I guess I'll say two things. The first thing I would say is I don't think it's the right way to go to compare a child rape case to any other kind of case, because society treats it differently and this court has acknowledged it's a different thing. And there are different rules with rape cases. We're allowed to put in expert testimony about delayed disclosure. We're allowed to bring in expert testimony to talk about anatomy confusion. So I don't think that's the right parallel to track here. If it's pattern evidence for a defendant, do we get to put that in? I think instead, thinking about it also in light of the stigma and the social issues, taboos, et cetera, that go with rape victims and rape skepticism, society's already skeptical enough. To add this extraordinarily small thing that is otherwise entirely different, right? There's no other relevant piece of information that you've been able to identify, despite having two complete saves.
I could understand if we were confronted with a case where there was a prior allegation against Berry that was generalized. I mean, clearly protected by the Rape Shield statute.
Well, maybe I would then add this, because I did focus only on child rape. I mean, you've seen what I could find on child rape. Making a rape shield exception where it's exceptional, right, it isn't just going to apply to child rape. And the next case I would then think about is a prostitute that's been raped by two different Johns.
Right, and
Who
then-
charges $20 for
That would be similar to the victim, in this case, sleeping in her living room. That's just the circumstances of the situation.
Right, and
Prosecutor
it,
would say, I got in the car, I was offered $50, whatever. There's the sameness in those.
and where both of these, where this victim was offered a reward, which we know is a common grooming technique, in order to do something sexual, now we're latching on the fact that the dollar amount that was associated with that.
I don't think it's that easy. So I would hope that you would concede that this was a pretty strong case for the Commonwealth against Mr. Jacques. And so in the context of, I don't think the Commonwealth's making the point that the statutory guarantee would make the constitutional guarantee yield. He has a right to present a defense, and in the case where the Commonwealth has all of this other evidence, this is what he has, right? So this is the impeachment of the complainant with the sameness of whatever you claim is just 2 out of 4 things with Mr. Berry. It's what he has. So tell me why his constitutional right to present his defense should yield to this statutory
sure.
rape shield.
So I'm not relying, I agree with you that he's always going to have a constitutional right to present, to cross-examine witnesses and impeach, but there are, and that's going to always trump the rape shield statute. Where it gets different is twofold. Number one, that the judge, we trust judges with the discretion to properly limit cross-examination to things that are probative and are not unduly prejudicial, and that wouldn't otherwise confuse or distract the jury or unnecessarily prolong the trial.
But that's a 403 argument. That's not the argument on the rape shield and the exception.
Well, respectfully, well, not respect, I mean, of course respectfully, but my argument, Judge, is when you look at whether or not the judge made the wrong call about this being relevant enough to have at trial, look at what the judge did, right? And look at I don't know if it was an hour's worth of discussion, but there are many, many pages over 3 different days where this judge tried to figure out how something this obtuse could be relevant at trial. And he then, only after figuring out that really there's minimal relevance to this, and he heard everything that the court has heard, and he read the same interview, and he said, please explain to me how this could be relevant. What is this probative of? And we still just get this, isn't it weird that, right? And so then comparing that to the prejudice to trial, the fact that ADA Sukanolfi is now going to have to prove the Berry case and rebut this idea that lightning doesn't strike twice, simply because he offered $20 for a dance on video. That's absolutely the judge's call, right? And it doesn't violate his constitutional rights. It doesn't violate the statute. It is the judge is always allowed to make relevancy calls here. And this judge, frankly, went over and above, right? Because he didn't have the benefit of a written motion. He never really got clarity about what this was probative of. And yet he went through...
Is it that opaque what it's relevant to? That the credibility of the complainant? Is it really that unclear?
I think it is, because I'm trying to imagine a different case, right, where a defense attorney says this person was mugged, and he said the person was wearing a red sweatshirt, and he said, give me $20. And then he pulled out a knife. And then a year later, he comes out and he says, yeah, this person had a red shirt, and he pulled out a knife, and he said the same $20. That's never coming in a case. A defense attorney wouldn't bother doing that. The reason a defense attorney is doing it in this case is because whether he's going to articulate it or not, he's looking for that to present this myth of the innocent victim, the righteous victim, the idea that lightning doesn't strike twice, so that the jury is then wondering, what's wrong with this kid? What am I missing here? Why does this keep happening to her?
I thought the theory was pretty clearly articulated, which was that this victim is pulling on her prior experience in order to get the defendant out of the house, because he is a strict disciplinarian as to her siblings. I thought that was the theory.
Well, certainly the theory of bias was, right, and that was well established. But corroborating that bias by introducing an entirely different, and really different in kind, right? Because when you look at it, Jacques, it wasn't simply an escalation, and she also did this. I mean, this was a serial series of sexual assaults, whereas Barry was looked to be a 1 or 2 off episode by somebody who was visiting the house, right? So you know, to say, you know, this is somebody who was aware. Well, as we get to Ruffin, right? I mean, that was part of the issue with Ruffin. This court made clear in Ruffin, it wasn't in order to help a defense bolster this argument they're making. Rather, it's to deal with the assumptions that society has about chastity norms, and that a youthful victim wouldn't know. So you really would be creating and opening the door to a brand new exception. You wouldn't be expanding Ruffin. You would be opening the door to a brand new exception for this substantial similarity idea to come forward.
Can I ask a factual issue? I'm reading through the motion session for a second. Is the $20 for dancing, is there a difference? I'm just reading here, Morrisbury propositioned them to have sex for $20. Mr. Jacques said that he would take them to take naked pictures for $10 or $20. So is this more distinguishable, that they're not exactly the same? I just don't know I haven't read the whole record here.
I apologize, Your Honor. I know that there was offering money for various
But were they
things.
offering money for different things? I mean, $10 for a picture versus $20 for sex, that's different.
And I should be, you know, I should be
just
more
don't know
familiar
the
with the
facts.
record than I am. But you do have the Sane interview where she discusses Barry, and it has everything in there. And
When we compare, so we've got to compare the record on that, because if it's the same $20 for dancing or sex versus, you know, money for something, you know, sexual but unrelated, we got to pin that down.
you would, but then again, I just the implication.
You don't think that, even if it's exactly the same, is relevant, but if it's different, that helps you a lot.
It does, but I would also say that we're also ignoring the implications of letting something so small then open the door to essentially the entirety of the Barry. It wouldn't just be, didn't somebody else offer you $20 to dance one time? It really would open up the whole door.
You may win on something easier, which is that it's not exactly the same, and you may want to win on something easier.
Well, I would, however, the court, I don't think, I appreciate that you mentioned from the very beginning how narrowly this court has always looked at the rape shield statute, and my concern isn't just for this case, it is for every case from this case, and so I appreciate that this court has recognized how concerning these can be.